Hello, everyone. Welcome to today's program, Writing to Win Part 2, Advanced Techniques for Persuading Judges. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Daniel Smith. Daniel's 40-year career of exclusive appellate practice has seen him appear before the California Supreme Court 19 times. His victories on appeal set precedents regarding punitive damages, tobacco and asbestos liability, election law, and employment. Daniel consults on briefs and appellate strategy and is a certified appellate specialist and belongs to the California Academy of Appellate Lawyers. We can't wait to hear what he has to share with us today, so I'm going to turn it over to him.
Thank you very much for that kind introduction. And just as a matter of housekeeping, I'm looking at a screen that says make CLE compliance a breeze. Does that mean I'm in the right place or I should be looking somewhere else?
Um, what I dropped in the chat is just the materials for people to
Okay,
click on the
but you're
videos.
you're getting my picture. All right. Is that correct?
Yes, everything's good, and we can.
Okay. Thank you. Thank you for that
Not a
reassurance.
problem.
Well, welcome to this seminar. I'm very glad to have you all attend. Some of you may have attended the previous presentation. And one way that this will be different, we've retitled it Advanced Techniques, is I'm going to talk more with this opportunity about the relationship between ourselves as writers and judges and law clerks as readers. And what we're trying to do is to maintain that relationship at a very high level so that our message gets through to help shape the reader's understanding of our case. A lot of writing advice is geared to a beauty contest and how wonderful and beautiful is your writing. That's not our goal. Our test is how effective is our writing, and in two particular aspects. How well do we engage the interest of the reader? Judges are not, we have to appreciate judges are not intrinsically interested in our case. And we have to find a way to engage their interest, whether it's in a factual pattern or a legal question, something to do with the judicial administration of justice. We have to find a reason for them to think that they want to find the answer to the issues that we're going to present. And then, secondly, we have to be effective in answering the questions that they have about our case so that they will come to our result. In my own career, I didn't come to appreciate the importance of what we are now discussing until I had been about 10 years out of law school, sad to say. And what brought it home to me was that when I would reread my own briefs before oral argument, I found them less easily comprehensible than I had wished, and not as persuasive. And so I set about reading every book I could get on legal writing, and I went outside the legal community. Many famous authors have written their own books about how to relate to the reader through their writing. Kurt Vonnegut, Robert Caro, E.B. White, and many others have spoken about the task of the writer, Barbara Tuchman. So I do want to mention right now at the outset some books that I hope you will pursue to pique your interest in becoming the most effective writer you can possibly be. And so here are some titles. They're in the bibliography, but I just want to mention them so that you might engage with these books yourselves. Now, in Strunk and White, which we probably all have 5 copies of somewhere in our boxes, the most important part of that book other than the mandate to omit unnecessary words. That's a very important part of that book, and we'll get to brevity in a minute. But the most important part of that book are the footnotes and the preface and the postlude that E.B. White writes around the notes that he took from Professor Strunk's course at Cornell when he took that course. E.B. White is sharing his approach to how he engages and shapes the reader's understanding. Very, very useful insights. Number two book is by William Zinsser, who is not as well known as he should be, but his book title on writing well is a real eye-opener and and a motivator. And the first 10 chapters, I highly encourage you to study those 10 chapters. I think you'll find it very inspirational. Brian Garner, who's the king of the legal writing field and a well-deserved reputation he has written many books, and I'll highlight two of them that I hope you will acquire and pursue. One he wrote with Justice Scalia called Making Your Case, and that's a very insightful book on how to take the judge's perspective. Scalia is not shy about articulating his perspective and what he wants in our writing. And Garner wrote another book called Legal Writing in Plain English, which I highly recommend. I would say there are two distinctions between this course and what Brian Garner teaches, and he's a friend. I've been to many of his courses. We correspond, so this is not a criticism. But Brian Garner is an academic. He's a professor at a law school in Texas, and he has not completely let go of what I would call are the shackles of academic writing. Um, it can be a little highfalutin. It can be a little overly elegant. Um, uh, and that's not what I believe we want to aspire to, because that's off-putting, I believe, to judges and to readers of all types. Um, what we want is to make our writing as easily accessible and not call attention to ourselves by our writing. We don't want our writing to leap off the page and say, yoo-hoo, to the reader, look what a wonderful writer I am. We want the reader to be concentrated on the message. We want to be a clean window through which the reader can see the content of what happened and how to apply the law to the facts of what happened. And the last book I'll recommend is Richard Whittick, a former professor at Davis Law School who wrote Plain English for Lawyers, and he really started the plain English movement. So happy reading to you. Those will all be enjoyable books, and they will reshape your nervous system and your awareness of how to write in order to to engage the reader, and to shape the reader's understanding of your case. Now, let me introduce a little bit about the materials and what you'll find here. And my hope, we won't be able to cover the materials in detail. There are 130 pages of advice on writing. What I hope to do in this hour that we have together is to motivate and inspire you to go through the materials at a leisurely pace and revise your own preferences based on whatever advice that you find acceptable and useful from your own perspective. Um, this book on persuasive legal writing is divided into subparts, all with the goal of achieving clarity in our writing. Before I discovered and developed my point of view on what creates clarity, I would outsource the briefs that I was filing in important cases to get the advice of others. And what I discovered is these were very accomplished writers in their own right, but their comments were not systematic in terms of saying, well, here's why this should be revised this way. And when I opened up my own law practice in 1983, devoted strictly to civil appeals, and hired an associate, I discovered that my comments to the associate were also not systematic. And the reason I knew that is that the associate would keep making the same writing errors, brief after brief after brief. In other words, I wasn't providing guidelines to my associate. And so I realized I have to provide him and me guidelines, and that's what you find in these materials, guidelines for how to engage the reader and how to shape the reader's understanding of our case. And so here are the five guidelines that I believe are essential to achieving clarity, which is what judges crave in our writing. And number one is brevity. We want to take out what doesn't need to be there so that then all that will remain is the essence. One famous example often taught is how does a sculptor create a statue out of a block of marble? Well, the sculptor would reply, I take away everything that is not statue. So we want to keep out of our writing everything that doesn't belong there, that doesn't significantly contribute to engaging the reader and shaping the reader's understanding. Number two category is simplicity. We want our words and our constructions to be as simple as possible. There's no shame in being simple. It's actually helpful. The third contributing factor to clarity is continuity. We want paragraphs to flow one to the next and to the next. We want sentences within paragraphs to flow according to an interior logic that we will discuss. And we need to link our sentences and our paragraphs so that we'll have a continuous train of thought. Category number four is appropriate details. Sometimes we burden the reader with too many details that are unnecessary, but other times we want the reader to recall the key details. And when we use pronouns or generalities to refer back to the most important factors in our case, whether it be a rule of law or a fact, we need to ring the bell and remind the reader of what those details are. And the fifth category of material in this book is appropriate design. We want a design that answers the reader's questions as they arise for the reader. So when we'll get to the design of your document and how we can answer the reader's questions in sequence in our document. But there's also a superior and preferred design to paragraphs and to headings and to sentences and to phrases so that they will come to the reader in the most easily digestible form. To give you an example, if I was going to make my case for you by presenting 10 numbers that were going to be the make or break fact in my case, if I present them in a hodgepodge like 2, 7, 6, 4, 8, 9, 1, 0, those would be hard to remember. But if I present them to you in a familiar sequence, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, they're easily memorable. So it's our job to do the thinking and the organization that presents information in a logical and memorable sequence. It is not the judge's job to dig out of our opaque and obscure materials the internal logic of our argument. We need to do that work. So let's dive into those five buckets that I mentioned, the contributing factors for clarity, with the question of design or structure. And I'm going to start, if you have the materials handy, at page 102 and chapter 8, the structure of the brief. And the goal of the brief and the parts of the brief is to present the information in the sequence that answers the questions that the reader has as those questions arise. Now, that takes some thought on our part to ask ourselves, well, what does the judge need to know on page one, and so forth, and we'll go into the parts of the document. Um, and I want to emphasize that you will make your writing job very much easier if you outline the sequence of subparts that I'm going to present to you and suggest you consider. If you work from an outline, because that will put all the information at the beginning in the place where it ultimately will end up. It's very hard to do and time consuming to do serious surgery on a brief late in the stages, late in the brief's development. So we want to start off in a way with like a foundation for a house. We want to have it well designed so that every room has a secure foundation at the beginning, and we don't have to come back and redesign the foundation. So the very first page of your document is a very important page because our goal, as I said, is to interest the reader and to shape the reader's understanding along the lines that benefit our client. And we will later in the hour come to the first paragraph of the famous Paul's case and whip that into shape to be a good first page for a brief. But your first page wants to have enough facts to be comprehensive and honest and persuasive. It wants to raise the legal issue that your case presents, and it wants to show the optimal resolution of that legal issue in favor of your client. That's a very challenging page to write, and I write mine sometimes 10 or 15 times during the course of brief preparation. It should get constant revision and constant brevity, constant reinforcement of brevity. If it spills out too long, it will be too taxing to be like a headline for the reader. Now, the reader is going to want to know next, what are the issues, what are the legal issues that need to be resolved? And so there's a section that I put in every brief called Issues Presented. I think it's required in the Ninth Circuit, but it's a good idea in every court to focus the reader on the issues that you feel need to be resolved, and then followed by a summary of argument in which you resolve those issues, explain why those issues should be resolved in favor of your client. Next might be a procedural history because it may be a factor in shaping the issues, but only as much procedural history as is germane and determinative of the outcome in your particular document. Don't be giving the entire clerk's transcript summary in your procedural history, only the pivotal developments. Then you'll have a statement of facts in which we want to use frequent headings and subheadings. Judges need help navigating the facts of your case. And so the more headings and subheadings that you can put in, they'll be visible in the table of contents, and they'll help the reader find exactly the facts that the reader wants at the time the reader wants them. Now, the argument part should include a standard of review, meaning how should the judge regard the facts? Is this like a summary judgment? So we're looking at all facts that might constitute substantial evidence should be included, or are we looking at on appeal a judgment after a trial where all inferences in favor of the trial result are indulged, and contrary evidence is not persuasive on appeal unless it totally refutes the other side's evidence. So the standard of review is often the pivotal linchpin or fulcrum for the outcome of your case. So you need to state it and show from authority that that is the correct standard of review. Now, in my writings, the argument part has five subsections. The first is sort of an introduction to the argument, an orientation of the reader to the parts of the argument that will follow. Um, the next part is discussing the rules and discuss them neutrally. This is a presentation of law. After you've presented the facts, you are going to argue and discuss the law. But it has to be credible. It has to be dependable. It has to come across as authoritative. And that's why it should be a neutral presentation of the law, as if you were the judge's law clerk, not biased for one party or another party, but simply presenting to the court the law as it is found. And if there's bad law against you, then you can point out the contrary law, but be honest and be complete. The next section of your argument will apply the law, the rules, to the facts of your case, whether they're procedural facts or facts about what happened in the real world. Wanting the next part to include or think about including is what Garner calls anticipatory refutation. Because your brief does not exist in a vacuum. And there's someone on the other side who's going to attack your position. Why not get in the first blow yourself and say, it is likely that my adversary will say A, B, and C. And here are the reasons why A, B, and C are not persuasive. So that way you get to color the judge's thinking for your side, and not have the judge encounter the objections to your position in the other side's following brief for the first time. You want the court to be familiar with both sides and understand why your side should prevail. All right, so that's one proposed structure for your brief. Let's turn now to the other components of clarity. And actually, before I do that, I skipped over one section that is very important. And that section number 1 starts on page 5 of your materials. And this section is devoted to pleading the judge's case for why they have a tough job. They have a tough job. They are time starved. They are swamped. They are overworked. And they often do work in very difficult circumstances. Judges from the courts of appeal and the California Supreme Court have told me that they read briefs while they're on buses commuting to and from work. They read briefs while they're on vacation, while their partner or spouse or a family member is driving. They're sitting reading briefs. I've had a judge tell me that he went to his vacation home on the coast, on the California coast, with a box of briefs for the weekend, and that was his weekend, was sitting in his vacation home reading briefs. I think we can all sense the challenge that it is to make reading our brief worthwhile. In a way, it's like television and everyone's competing for eyeballs. Well, we're competing. We're competing for eyeballs. We're competing with all the other entertainment or recreational activities or the committees that the judge has to deal with. We're competing with the judge's other work. Appellate judges, when I was practicing, had to sign off on 30 cases a month. 30 cases a month, 10 of which they would write themselves, and 20 of which they would sign off on other judges' briefs. Well, that's more than one opinion a day. There are 22 working days in most months. That's more than one a day. We're competing. And if we can do the most effective job, the shortest job, the quickest job, the most easily readable job with our briefs, judges will be grateful and they will favor our side simply because we helped serve them. Um, and I want to emphasize here, there's a shift in mentality when we start to write our brief. Uh, after we've worked maybe through a trial, or we've worked through reading a transcript, we've worked through doing legal research, and all that is in a sense, in my experience, client oriented. I'm client facing. I'm working on behalf of my client and telling, I'm discovering and summarizing the supporting facts and law for my client. But then after I've collected those, I need to present them in easily digestible fashion to the court. And what I'm proposing is that we take into account the difficulties that judges have in even finding time to look at our document. And so we want our document to stand out for the ease that it brings to the court in reading our document. Joe Montana, a famous San Francisco 49er quarterback, said his job became a lot easier when he realized he was just a mailman trying to deliver the football to the person who could do the most with it. And so that's our job. We're delivering the goods to the court, and hopefully the judge will do the right thing with it. So I wanted to take that little detour because it's very important for our nervous system to realize we have a job to do, and it's to make the judge's job easier. Aristotle said there are three bases for persuasion: um, logic, emotion, and character. Ethos is the Greek word. And by the quality of our writing and the way in which our presentation makes the job of the judge easier, we distinguish ourselves with reference to character. And there's a quote in the materials about does good writing get rewarded by judges? And the answer from this judge in Texas was yes, it definitely does get rewarded. And there are other quotes from Ruth Bader Ginsburg and from many other Supreme Court judges about the benefits that they feel when we take care with our writing. All right, sorry for that self-interruption, but let's go back now to the second uh, element of clarity, which is brevity. Just as a reminder, I talked about the design of the document when we went over that. That's one of the elements of clarity that all the judges' questions will get answered in our document in the sequence in which those questions arise for the judge. Now we're going to talk about how do we craft, what are the guidelines for crafting persuasive paragraphs, persuasive sentences, persuasive phrases, and we have four of those hallmarks: brevity, simplicity, continuity, and appropriate details or specificity. So let's talk about brevity. The discussion of brevity starts on page 14. Now, one of the ways to achieve brevity is to realize whether what you're saying is germane and essential or colorful and unnecessary. We have so many facts that we want to pile into our document because we've worked so hard to dig up those facts. And we have so much law that we could put in because we did a lot of hard work on the research, the legal research. And the filter that I'd like you to apply when you edit. And by the way, these writing qualities are best applied in the editing, not necessarily in the writing. And I'll take a little detour here to explain how new habits are, how I see new habits being developed. We go through several stages of acquiring a new skill. And the first stage is when we have, when we are unconscious that we lack this skill, that this skill is required. Then we become conscious that we lack a skill, and then we could become conscious of acquiring the skill, and the height, the climax is the unconscious implementation of the skill. I'll give you an example. If someone wrote a sentence that said, he jumped to his death, crazed with jealousy, the skillful writer's nervous system would say, that sentence is incorrect because it puts the information in the wrong sequence. The correct sequence would be to put cause before effect. And so therefore, and climax at the end, and to conform to the sequence of time. So that sentence should be revised to read, crazed with jealousy, he jumped to his death. So we want to get our nervous systems to the point where we sense when something has been written in a manner that's clumsy or dense or difficult for the reader to parse. And we do that in the editing. In the drafting, we don't want to edit and draft at the same time. It's like driving with the brakes on. You need to be in touch with your creativity. You need to free associate. You need to get it on the screen. Don't inhibit yourself during the drafting phase. But then come at when you're done or when you want to do a section and print it out. And please don't think that you can edit effectively on screen. It's just not possible. You need to see it on black and white. And then take the blue pencil to your writing to conform to the guidelines that you've decided you want to follow in your writing. And the first one that I'm recommending here is brevity. And the filter for brevity is to decide, did I write something that's unnecessary to the outcome? Or did I repeat something that I have already said and I don't need to repeat it because I said it well the first time? Or am I stating something that is implicit, that the court would understand anyway from everything else that's contained in the document? And so to delete down to what is the core of your argument, of your persuasion, of your brief, take out anything that's unnecessary, redundant, or implicit. And do that in the editing phase, not in the creative or drafting phase. And I have some at page 17, if you have the materials, we can take a minute to see what brevity can accomplish in making a presentation more powerful. Just as a refresher, uh, the Palsgraf case was a case where the woman standing on the railroad platform was struck by some scales that had been dislodged by a fireworks explosion at a far distance down the platform. And Justice Cardozo, who is a very good exemplar in his writing of how not to write, his writing is not plain, it's not concise, it's elegant and beautiful and opaque. So he crams in a lot of details in his opening paragraph for the Palsgraf case, and the reason they're needless details is because they do not relate in any way to the rationale for his outcome. His outcome is that the explosion of the fireworks that were dropped by the man boarding the train was too far away in distance and in causation from putting any liability on the railroad for the fact that those fireworks exploded. And here are some of the facts that are not essential to that conclusion. For example, Cardozo tells us that there were two men running for the train. You might have forgotten about that second man. Well, it's not your bad because the second man had nothing to do with the explosion of the fireworks. Only one man was carrying the fireworks. So we can delete the reference to the second man. Uh, he tells us that the plaintiff, who was standing underneath the scales, had bought a ticket to go to Rockaway Beach. Well, it doesn't really matter for liability whether she had bought a ticket because trespassers are owed a duty of care. So she didn't even, you don't need to establish that she bought a ticket or that she was going to Rockaway Beach. If she had been going to some other place, the liability of the railroad would still be the same. Then he repeats a couple of times about the fireworks being concealed. He says it was a package that was covered by newspaper. And he then adds the redundant language, but there was nothing in its appearance to give notice of its contents. Well, if it's covered by newspaper, we already know that, and so he's adding something that's implicit. And at the end of his first paragraph, he also writes something that is definitely implicit. The full sentence is, the scale struck the plaintiff, causing injuries for which she sues. Well, I don't think any of us need to be told at the beginning of a judicial opinion on her lawsuit that she had sued for her injuries. So that's the kind of sharp editing, aggressive editing that I encourage you to do to take out the burdensome, trivial details that are not essential to shaping the court's understanding of your case. Let's go to our next writing quality for clarity, simplicity. And that starts on page 22, section 2.4. Now, this subchapter starts off with many advocates of simplicity, and I'm going to spend just a minute on this because many of us excelled in college and were in law school and were rewarded by professors for complexity. And in the academic community, complexity is rewarded. It shows the powerful intellect of the writer, and that's a good way to write articles and get tenure in the academic world. But our goals are not to display our grasp of complexity. Our goals are ease of parsing. And so in our universe, simplicity is a virtue. And I had the help of Judge Alex Kaczynski of the Ninth Circuit, and when I wrote him about this book that you're receiving with this course, and I asked him what his opinion was of these virtues that I had identified, brevity, simplicity, and continuity, and he focused on simplicity, and he returned an email to me. I didn't realize a busy man like that would have time to write back, but here's what he said: simple, direct language is more persuasive than convoluted language. Simple language is more easily grasped and forces us, the writer, my addition there, but forces the writer to focus. I'll make it plural. Unfortunately, he used the masculine. Forces writers to focus their thinking and sharpen the argument. Second, he says, abstract language has a tendency to be soft and ambiguous, easily waved aside by someone leaning the other way. So simplifying and clarifying is really the essence of advocacy. Now, and there are many other endorsements of advocacy from E.B. White, from Hemingway, from Lincoln, Mark Twain, Shaw, Brian Garner, Kurt Vonnegut, C.S. Lewis. If you needed any encouragement to write to write simply, I know it's painful to give up those highfalutin words and phrases and constructions, but it's really called for in our practice. I happen to have a chance to serve on the instructions committee that in 2003 issued the CACI, CACI civil jury instructions that were revised into plain English. And we changed what was the old instructions were in BAJI, the Book of Approved Jury Instructions, and they were complex and dense. And here is one of them, um, which I'll read to you. Failure of recollection is common, period. Innocent misrecollection is not uncommon. Well, we wrestled with that and we revised it into the following plain English as follows. People often forget things or make mistakes in what they remember. So I think you can feel how easily understood the Casey revision is and cast your vote in favor of simplicity. If you want to contrast someone with Cardozo as a writer and find someone whose writing you'd like to emulate, Justice Oliver Wendell Holmes uh, was a very plain-spoken and plain-written judge. And I encourage you to study some of his opinions to become familiar and content with simple writing. By the way, I should have said I'm open for questions at the end, and I'll stop at about 20 minutes after for questions. Let's talk about continuity as our fourth quality of persuasion. We have some advocates of continuity here at the beginning of this chapter. Scalia and Garner said, this is what they wrote in their book, Making Your Case. Abandon interesting and erudite asides if they sidetrack the drive toward the point you are making. So we might feel that colorful asides are interesting and worth reading, but it's such a difficult task. Our task is really difficult to make marks, black marks on a white paper, and have those marks change someone's mind. To have someone see a situation the way we want them to see it. So let's not burden ourselves or impede our persuasive power or dilute the persuasive power of our writing by having jumbled sentences, jumbled phrases, paragraphs that don't flow. We want a clear train of thought. So on page 28, I offer you 8 tips for maintaining continuity in your writing. One we've already mentioned from Scalia and Garner, which is stay on message. No detours, omit interesting but peripheral information that fails to directly advance your point. Point number two, no gaps. You can't have a space, intellectual space between the component parts of your argument. So connect points by developing them in a logical sequence and then also using signals, which are mentioned and listed elsewhere in the book, signals that say in addition or moreover or similarly, so that the reader knows that this is part of a continuous train of thought. Start paragraphs and sentences with familiar information and then introduce the new information. Take the reader where the reader is or where you left the reader, and then add the new information. Lead with your point. Don't build up to your point. It helps the reader to know where you're going from the beginning. So this is an abandonment of the Aristotelian method of persuasion and the Aristotelian method of argument, which was to build one point on top of another point and top of another point until you reach the climax and the conclusion. That's not helpful persuasive writing in our day. The reader, spill the beans is the informal message. Let the reader know at the beginning what your point is, and then show how your subpoints connect to reach your conclusion. Now, let's talk about the gap between the heading and the paragraph. A heading, by the way, in my view, asserts a point, not just names a point. So, for example, if you were going to discuss the complaint and you had an issue with the complaint as to whether it was breached or not, your heading would not be the complaint. Your heading might be the complaint failed to allege. Your heading wants to assert a point about the complaint or the contract or the accident or the surgery. Don't just use those titles. Say something about it that reflects your point. Another way to create continuity is to connect quotes to your train of thought. The reader might not dig your point out of the quote. So what you want to do or to consider is before the quote, insert your own interpretation, your own application of what the quote means. And then after the quote, make the application to your case. There's a gap between a heading and the paragraph. As I've just said, I recommend that the heading assert a point. Now, to create continuity, the first sentence of the paragraph should restate that point. It could almost imitate the language of the heading so that you can reassure that the reader that the paragraph that's now coming develops the point that was made in the heading. Often I read briefs where there seems to be no connection between the heading and the first paragraph to follow. Don't let that happen with you. All right, our next point and final factor for clarity is appropriate detail. And what I mean by that is at a certain point in your document, you're going to present all the details about the facts or all the details about the law. But then when you later refer back to those facts or to that rule of law, you want to ring the bell that you rang initially. And the reader won't recognize that unless you use enough detail to remind the reader what it is that you're referring to. So the fault occurs most often in legal argument. Someone will say, well, the second holding in the Palsgraf case was clearly erroneous because, well, the reader might not remember what the second holding of the Palsgraf case was, even though you did mention it 2 pages earlier. I worked with retired Supreme Court Justice Marcus Kaufman on a brief, and in a phone call, he urged me. He said, "Don't write as if you have to make the reader think, because the reader might not." And I took that to heart. He certainly read enough briefs to know the difficulty, um, and seen enough problems with other judges and with law clerks that they might not think and connect things. So we want to make it easy for the reader to connect all the parts of our argument. And therefore, if instead of saying the second rule in the Paulsgraph case had a fallacy, might want to say the second rule about foreseeability, or the second rule holding that the accident was too remote from its cause. That little phrase really helps the reader uh, understand the reference back. So appropriate details can aid the reader's understanding of what it is that you're saying, and generalities may skip right over the reader's head. Um, I think that covers the content of what we want to do here today. I want to encourage you to change your mindset. When you get to the writing and the editing stage, you are actually becoming something in addition to being a lawyer. You're becoming a good writer. And you are now engaged in an art form that many, many, many people make a living at. And the way they make a living at it is to engage their readers. They meet their readers' needs, whatever those might be. And as Barbara Tuchman wrote in one of her books on writing, that she wanted to make the reader want to turn the page. And if we can embody that kind of energy and that kind of engagement with our readers will both be more pleased to read our briefs and more influenced by our briefs. So let me take a stop here and see what questions there might be that I can answer. Okay, David Wong asks, and it's not a dumb question, why is it more effective to edit on written paper and not on the screen? Well, there are a couple of reasons. First of all, the reader is going to see it on the paper, not on the screen. Or they may read it on the screen, but I'll give you a second reason, which is editing often has to do with parts that flow from one page to the next. And as an editor, you need to see, it's helpful to see the entire context of what you've written when you're editing it, to see what did I say about this before, and what did I say about it next. So that's just been my experience. I'm not sure I can give a better answer than that. But to have only the part visible that can appear on the screen, I think is hampering, impedes effective editing. Ah, okay. Christine, this is wonderful. Thank you for that question. The question is, um, when we read cases, and this person's a third year law student, when we read the cases, they don't follow our principles, and that is sure true. That is sure true. There are a couple of reasons for that, and a highlight, and it's in the materials, is Pennoyer versus Neff. That's a 19th century U.S. Supreme Court case on jurisdiction. It is really, really dense, and you have to really dig to get the holding and the basis for the holding. So judicial opinions are generally not a good guide to legal writing for a couple of reasons. The one, the court doesn't have to work to earn our approval or to earn our acceptance. The court doesn't have to do the work that I'm recommending we do to be authoritative because the court is the court. And so they don't follow these clarity principles because they're not having to earn our respect or trust. Now, another reason is, and California Supreme Court clerks have told me this, we don't write better because we don't have time. We just don't have the time to go over that, to do a third or a fourth edit. And they may not be familiar with the principles of clarity. It'll happen in your career when you're writing for a senior partner. The partner will write in the margin unclear. Well, that's not actually very helpful, as we've seen. I have 130 pages of instructions and guidance on how to make things clearer. So a lot of lawyers and judges haven't really thought through what is it that helps, that creates clarity. When you write clearly as a clerk, how would your judge do it? You'll have to have a conversation with your judge as to whether that judge is comfortable writing plain English, and you'll have to do it the way the judge wants it. But when you get out on your own, you can follow these principles. Okay, thank you for that compliment. Writing well is a lifelong lesson. Yes, you're grateful. Thank you for saying that. Here's a person, Judith. You agree with printing out when possible. Yeah, you can't minimize the screen to see several pages at once. It does give you a different perspective. Any other questions that might be coming up here? I see open 5. Oh yeah, here's one more. So this Judith is raising the problem of someone senior to you having a different preference in writing style. Um, all I can say, Judith, is make your case, show them Scalia and Garner, show them Scalia's book on plain English for lawyers, Richard Whittick's book, a law professor at Davis, Plain English for Lawyers. If you think this manual that you've just obtained in this course would be persuasive, and the authorities that I cite, I wasn't able to cite because of time all the Supreme Court judges and judges from other courts who endorse these principles of clarity. But they're on your side and you're on their side. So hopefully you can do it, create a quiet revolution in your law firm, and to get them persuaded that plain English, although it's not remarkable, it's remarkable for being unremarkable. We don't want the attention to be on what great writers we are. We want the attention to be on what a great case we have, and why our client should win. All right, I think I've covered the questions, and hopefully we have 30 seconds left for me to thank you for being part of this seminar. I hope you find it beneficial. Good luck to you in your careers.